Good day. My name is Roberto Alcazar. I am a retired judge of the Superior Court of New Jersey. Bear with me on the next sentence in Spanish. Si usted necesita un intérprete porque usted habla solamente español, por favor póngase de pie. If you need an interpreter in any language, please indicate that by standing up at this point. We are about to call a list of cases where the landlord is suing to evict, that is, to lock out a tenant. After the list has been called, you will have a chance to ask questions. Written copies of the instructions that I am about to give you are available. I will explain the calendar call. When we call your case, please identify yourself. We will mark a case ready when both the landlord and the tenant are here. We will mark a case default when the landlord is present but the tenant is not. If a default is entered, then the landlord must file an affidavit or certification, which must include the facts necessary to get a judgment for possession and a statement that all charges and fees are permitted by law and the lease. The landlord's attorney, if there is one, must also file a certification that the charges and fees, including attorney fees, are permitted by law and the lease. The judgment for possession allows the landlord to have a tenant evicted by a special civil part officer. We will mark a case dismissed if the landlord is not here. Tenants should identify themselves even if the landlord is not here. Everyone must stay here until you get additional instructions and permission to leave. Now I will explain about settlements. After we have called the list of cases, we suggest that landlords and tenants talk to each other to try to settle your cases. Here are some important points. You do not have to settle your case, and you have a right to a trial. You should settle only if the terms are agreeable to you. A settlement must be voluntary to both parties. If you're able to agree on a settlement, please let the staff of this courtroom know, and you will be given a settlement agreement form. The landlord and the landlord's attorney, if there is one, will file a certification with the clerk of the court. The parties are not limited to the contents of the settlement form. You may change them as you have agreed. Complete the forms, date, sign them, and give them back to court staff. You will receive a copy for your own records. Make sure that you understand the words in the settlement, because if you agree to the entry of a judgment for possession and don't comply with the terms of the settlement, you will be evicted. Any agreement that says a judgment for possession will or may be entered must be approved by a judge of the Superior Court. Now I will explain what you need to know while you're waiting for trial. If you're not able to settle your case, you will have to wait until a judge is available to hear your case. We expect to reach all cases today. However, if your case cannot be completed today, then the tenant may have to deposit with the clerk of the court the amount of rent to be determined by the court no later than 4:30 p.m. today, in cash or money order, a bank's cashier's check, made payable to the Treasurer, State of New Jersey, rather than to the landlord. If it is deposited, the clerk will reschedule the case with a new trial date. If the rent is not deposited today, a judgment for possession will be entered in favor of the landlord. That means that a landlord will be able to have a tenant evicted by a special civil part officer. A landlord cannot lock out a tenant on his or her own. A special civil part officer must be used to evict the tenant. I will now explain what happens in non-payment cases. The following points relate to a landlord's claim that a tenant owes rent. 1. Dismissal upon payment or deposit. First, if the landlord claims that the tenant owes rent, it is still not too late to pay the rent that is due and have the case dismissed. If the tenant pays the rent that is due plus costs of court by 4:30 p.m. today, the case will be dismissed. The tenant may pay the rent plus costs to the landlord or to the clerk of the court by cash, money order, or bank's cashier's check. If a tenant disagrees with the landlord on the amount of the rent that is owed, a tenant has the right to a trial so that the judge can decide how much rent is owed. After the judge decides how much rent is owed, the tenant can pay the rent and the case will be dismissed. 2. Items constituting rent. A tenant does not have to pay for attorney's fees, late fees, or other charges to avoid eviction unless there is a written lease that calls these items, quote, additional rent, close quote. Even if the lease does say that, it may be limited by rent control or public assistance. Also, the rent may be limited by federal law. For example, if a tenant gets Section 8 assistance, the landlord cannot include a late charge to determine the amount that the tenant owes. 3. Limitations on court's powers. If the only issue is that a tenant who owes rent wants more time to pay it or pay it in installments, but the landlord does not agree, then the judge will have to enter a judgment for possession. The judge may not make a landlord wait for the rent or to take it in installments. I will now explain eviction procedures. A judgment for possession is the court order giving the landlord the right to possession of the premises. However, the landlord cannot actually evict the tenant until the warrant of removal is issued, served, and executed timely. A judgment for possession gives a landlord the right to request a warrant to have a tenant evicted by a special civil part officer. The warrant for removal may not be issued sooner than 3 business days after entry of the judgment for possession. The warrant will have to be served by the officer on the tenant, and a residential tenant may not be evicted sooner than 3 business days after it has been served, but not on a weekend or a holiday. To put it very simply, a residential tenant may not be evicted any earlier than 8 days plus holidays after a judgment for possession has been entered. I will explain how to stop or delay an eviction. After a judgment for possession has been entered, a tenant may still try to make an agreement with a landlord to stop an eviction. If the landlord does agree, make sure that the agreement is in writing and that a copy is filed with the court. If the landlord does not agree, then even after a warrant of removal has been served on a tenant or after the tenant has been removed, the tenant may apply to the court as soon as possible for relief to stop the eviction or put the tenant back, including 1. An order to show cause based on Court Rule 4:50-1, requesting that the judgment for possession be reversed and the complaint be dismissed if the tenant can show good reasons. 2. A delay of the eviction because of the unavailability of other dwelling accommodations based on New Jersey Statute 2A:42-10.1 or 2A:42-10.6. That delay cannot be for more than 6 months and must be applied no later than 10 days after the eviction. But the tenant will have to pay all rent and proper costs. 3. An application for orderly removal requesting more time to move out if there is good reason. A court may grant or deny these applications, and if one of these applications is granted, the court may also establish certain conditions. Landlords who want to evict the tenant when they either purchase the property from the tenant while the tenant remained an occupant or gave the tenant an option to purchase must stay here to testify in court even if the tenant isn't here. This does not apply to most eviction cases, however. With respect to services available, we have a list of agencies that may assist you with rent, temporary shelter, or legal services. A list of these agencies or legal services programs and a copy of this announcement is available, and you should get a copy if you do not have one. Please wait until The list of all cases has been called and additional instructions have been given.